Hello, everyone. Welcome back to the LAOT Podcast. I'm Arnav Mathur, and today's conversation is about a part of the Constitution that almost everyone has an opinion on and is truly multidimensional. When we argue about reservation in India, we are mostly arguing about two things: seats in colleges and posts in government service. There is also a third domain which determines who gets to make law in this country. Reserved constituencies play a very big part in how our democracy functions. The question for today is whether, in the absence of a distinct theory of political representation, our courts have been deciding cases about political power using a vocabulary borrowed from somewhere else entirely. Now, here's where things stand, and I'll give the context for this conversation. Of 543 Lok Sabha seats, 84 are reserved for scheduled caste and 47 for scheduled tribes. 74 women were elected to the 18th Lok Sabha, which is about 13.6% of the House. The one-third quota promised to women by the 106th Amendment in 2023 is still not in effect because it's linked to a delimitation exercise. There was an attempt to introduce it in the previous session, and the bill was defeated in Lok Sabha. Now, coming very quickly to the local body story, the Telangana raised the backward class reservation to 42%, pushing the total reservation to roughly 67%. The High Court stayed it and the Supreme Court refused to intervene, holding that the 50% ceiling stands. In Maharashtra, the elections were stalled since 2002. Now they've finally gone ahead. But the results in over 50 local bodies remain on hold, pending a ruling on the state's revised OBC quota. And the court has signaled that the remaining polls must stay within the same ceiling. So effectively, we have a constitutional guarantee that is hostage to a census and a delimitation exercise that has not happened. A 50% ceiling under sustained pressure by the states across India, and a body of doctrine that was arguably never built for this domain in the first place. To help us think through all of this, we are joined by Dr. Sidharth Chauhan. Dr. Chauhan is an assistant professor at NLSIU Bangalore, where he teaches Indian constitutional law, legal philosophy, and comparative public law. He read law at NLSIU, received his LLM at the University of Pennsylvania. He also taught at Nalsar, Hyderabad for 11 years before returning to NLSIU in 2024. And his doctoral thesis is titled Juridical Engagement with Electoral Reservations in India. It was completed at Nalsar and submitted in June last year. It's the most sustained doctrinal treatment of this question that we've come across. So it's really a pleasure and a privilege to have you join us today, Dr. Chauhan. Thank you so much.
So thanks, Arnav. Thanks for having me on this podcast. I only recently came across the previous interviews that you've done. And it was good to see that you have a mix of scholars and practitioners and even people working on policy. So I hope that this will become a useful resource for both law students and others interested in the legal system.
Yes, sir. So let me start with the issue at the center of your dissertation, which is the neglect itself. Reservations in education and public employment have generated enormous jurisprudence. You from Balaji through Indra Swami through Nagraj, General Singh, and now the Vinder Singh. You've got a host of cases. Electoral reservations, which are older than both these other types of reservations and arguably also more consequential, have produced very handful of judgments and jurisprudence. Why do you think that is?
Yeah, so great. That's actually the starting point for why I worked on this theme. So as I've said in my acknowledgements, which I wrote when I submitted my thesis, the actual origins of this idea were from the period when I was a law clerk in the Supreme Court. I had a chance to work under Chief Justice K.G. Balakrishnan between 2008 and 2010. And it was actually in the first half of 2009 that I had the chance to observe the arguments in a couple of cases that were directly touching on the policy of electoral reservations. So, of
Hmm.
course, in terms of formally registering for a PhD, doing a structured literature search, and trying to write about it in an argumentative way is a process that came to be much later when I was there at Nalsar, which is where you're studying now.
Yeah.
But that actually happened much later. So for me, the original point of departure was that even as an undergraduate student, I had read fairly about reservations in government jobs and reservations in educational institutions. And we
Hmm.
were also taught largely through a case law method by Professor Uday Raj Rai, who had taught us constitutional law. I remember sitting in his classes in 2004 or 2005. And
Hmm.
at that time, it didn't really occur to me that
Hmm.
we are not really talking about electoral reservations. So I
Yeah.
think it was largely listening to the arguments in the cases which were later reported as Union of India versus Rakesh Kumar, which was a three-judge bench. And then, of
Yeah.
course, the main case which I discuss in my third chapter, which is Dr. Krishna Murthy, which
Yeah.
was a five-judge bench decision. It was listening to the arguments, especially of Mr. Arvind
Hmm.
Datta, who
Hmm.
was a lawyer in that case, which really, alerted me that this is an area which previously has not been studied very carefully. And
Hmm.
frankly, when I finished my judicial clerkship, also I didn't think too much about it.
Hmm.
It was only, I think, in 2015 when Professor Amita Dhanda, who was our senior colleague, was pushing us to think about new research questions that I finally settled on this question. So I don't think it's a description which will occur to somebody unless you've had insider access to the system. But
Yeah.
now that I think about it, now that I explain it to a larger audience,
Hmm.
I generally give two reasons.
Yeah.
One is that the electoral reservation scheme itself is not found in the fundamental rights. And
Hmm.
I say this quite clearly in my dissertation that is actually a reason as to why it has not been litigated as much, both
Hmm.
in terms of number of cases going up to the High Courts or Supreme Court, or
Yeah.
even commentators in the field of constitutional law picking up on it. So naturally, reservations which are traced back to Article 15.4 or 16.4 are likely
Yeah.
to be litigated more often because there is a question of rights, which
Hmm.
is linked to the design and enforcement of these reservations. Whereas electoral reservations, as since you have read the text, you know that the textual basis appears for the Lok Sabha in Article 330, for the Vidhan Sabhas in 332. And of course, I spend a lot of time in my dissertation on the
Yeah.
interpretation of 243D and
Yeah.
243T, which are providing for electoral reservations in local government. So,
Correct.
frankly, I think the first and most important reason is the fact that they are not part of the fundamental rights chapter.
Hmm.
That's the reason why they've been understudied. A
Yeah.
second reason, which I think is something which I've been able to articulate better after having written this thesis, is that political reservation talks about a limited pie. It
Hmm.
basically addresses the number of seats in parliament, the number of seats in the Vidhan Sabha, and the local body
Hmm.
reservations have largely happened only after the 1990s. Whereas if you
Yeah.
compare empirically the number of university seats available in public universities, both central or
Hmm.
state, as well as government jobs across various departments, just the pool of seats
Hmm.
and the number of opportunities at stake are much higher. So I
Yeah.
think both in terms of textual treatment and also in terms of the empirical effects of these
Hmm.
policies, those are the two obvious reasons why this area has been neglected. A third reason,
Hmm.
which I have actually not said in my dissertation, but I generally keep it for opportunities like this,
Yeah.
where there are engaged readers and listeners, is that another reason why it hasn't been litigated as much, at least, is
Hmm.
because elected lawmakers have already accepted this arrangement at the stage
Correct.
of candidate selection, at the stage of contesting elections. So even
Hmm.
political parties who may gain or lose from the
Hmm.
long-term impacts of electoral reservation will not be conscious of the fact that either
Yeah.
opportunities have been set back or further opportunities have been given. So I think these are some of the structural reasons, but
Yeah.
certainly we can think of more nuanced reasons as we go along in the conversation.
Yeah. Yeah. It's really interesting that, I mean, once they're part of the system, then they're either beneficiaries of the system, or they feel that it doesn't make sense for them to then litigate when they're already within the system. So I
Yeah,
think that
I
could
mean,
become a
the simple
disincentive
analogy is
for litigious.
if you've used your own family money to build your own house and you know that there might be irregularities, why would you go to court against yourself,
Hmm.
right? So I mean, that's a sort of rough
Yeah.
analogy that one can use. Yeah.
True. Understood. So let's move on to understanding some historical context for reservations in India and how it may or may not still continue, or the logic may or may not still continue in modern India. So the Indian Councils Act of 1909 introduced separate electorates within a franchise, limited by property and education. Then came the 1919 reforms that extended separate representations to Sikhs, Indian Christians, Anglo Indians, and Europeans. Then that became the precursor for the demands on behalf of the depressed classes. You had
Right.
Ambedkar's proposal for a double vote, then the communal award, Gandhi's fast, and the Poona Pact ultimately settling these questions. One of your core claims is that the colonial state's interest in affording group representation and reservation was fundamentally different and cannot be carried forward to independent India. What is this distinction and how does that operate?
Yeah. So actually, it's not an original argument that I'm making. I'm relying upon the work of Professor Valerian Rodrigues, the political
Hmm.
theorist, who has actually
Hmm.
done extensive work on Ambedkar's original texts. In fact,
Yeah.
for students who may be listening to this podcast, Valerian Rodrigues had published the collected works of Ambedkar in 5 volumes with annotations in the early 2000s. And for me, the distillation of that argument came in a series of articles that he published in domestic journals like the Economic Political Weekly and Seminar, which he has now recently put together as a book on Dr. Ambedkar as a political philosopher, where he has in fact made the same argument.
Yeah.
So he says that attempts at distributing not just political power, but also economic resources and social capital in the colonial state were tied to the logic of
Hmm.
consociationalism. The idea that you distribute not
Hmm.
only the benefits of government, but you also distribute opportunities for participation in government amongst different communities, because otherwise there is a continuous risk of
Yeah.
tension and violence between these communities. So, especially with respect to the 1909 Act, that argument actually applies quite squarely,
Yeah.
because the introduction of the double vote for Muslims, for instance,
Hmm.
was both a consequence of the Bengal partition and it was
Hmm.
also an attempt by the colonial state to balance
Hmm.
interests between the Congress and the new party, the Muslim League. By 1919, it's very interesting. The
Hmm.
story is not just limited to Sikhs or Christians or Anglo Indians who are demanding similar safeguards in the colonial legislatures. But as I've tried to argue in the second chapter of my dissertation, there are actually commissions, including representations made to British legislators and British governors, especially in Madras, where the caste question is brought up quite
Hmm.
explicitly in terms of the domination of the
Hmm.
legislatures or the domination of the professions by the Brahmins. And Dr. Ambedkar then later makes a similar argument when he gets elected to the Bombay Legislative Assembly. So the
Yeah.
argument which Professor Valerian Rodrigues draws from a careful reading of Ambedkar's own original texts, which were largely dated back to 1919 to 1947, he says that broadly the colonial state's logic is consociational. They're simply trying to keep the peace, or they're trying to maintain law and order by ensuring that the
Hmm.
distribution of political power and its
Hmm.
fruits is a method of preventing further conflict. However, that cannot be the underlying
Yeah.
philosophy of the constitution. When you're enforcing it for a country where you're also opting for universal adult franchise, there's certainly an argument
Yeah.
of group differentiated rights, which scholars like Rochana
Hmm.
Bajpai have developed with depth in the late 90s and early 2000s. But I think the simple claim that Professor Valerian Rodrigues makes is that this is exactly what Dr. Ambedkar himself was saying, not
Hmm.
just as the chairperson of the drafting committee in the Constituent Assembly, but even earlier when he was a member of the Bombay Legislative Assembly as a social activist in public speeches, and later even with the political parties that he organized.
Yeah.
So it might sound like revisionist history, but frankly, if you engage carefully with the works of Valerian Rodrigues, the shift from the logic of consociationalism to what we now call the logic of social transformation is
Yeah.
actually documented quite well, both on
Hmm.
part of people who were involved in the drafting process and also later attempts to characterize what is really the main goal of these policies.
Yeah. So it's the underlying idea of representation for maintaining peace versus representation for creating a nationhood and shared government as being the fundament on which our society or our nation is organized. So that change is something that we have to think about really carefully. Thank you
Yeah,
for that
and it's
answer.
not and it's not just representation for empowerment, which is I think a
Yeah.
common misconception these days. It's
Hmm.
representation, as you correctly said, which is quite foundational to the imagination of the new Indian state.
Correct.
That's the argument which Valerian
Yeah.
Rodrigues makes.
Understood. Absolutely. Um, let me move on to the next one of the biggest claims that you make, which is that courts have repeatedly imported doctrines that are built for education and employment into this domain of electoral reservations and representation. And you speak about different types of cases, specifically the eligibility type cases and the challenges to reserve chairperson posts. Could you explain what this difference is between reservation for education and employment versus political representation and reservation? What is the difference, and why should we care about this difference to begin with?
Yeah. Yeah. So I think at a very literal level, the opportunity to attend university, a public
Yeah.
university, of course, or an opportunity to gain employment in a government public sector undertaking or a ministry is fundamentally different from being elected to office, because
Hmm.
both in the domains of education or employment, the presumptive benefit is primarily being conferred on the individual who is
Hmm.
accessing these institutions. And then there is an assumption that there will be intergenerational mobility, that
Hmm.
the person who comes to university will then be a role model or an incubator for others who may then come to the university, even if their communities were historically denied this opportunity. And with public services, the
Yeah.
argument is a little more complex, because representation in the bureaucracy may also have an impact on decision making, which may then bring the sensibilities or interests of a particular stakeholder to bear. Now, my argument is that electoral representation is actually prior to representation in the domains of higher education and the domains of public sector employment. Because ultimately, if you think about the arrangement of power under the Indian Constitution, the framers
Hmm.
might have placed electoral reservations outside the domain of fundamental rights. But that should
Hmm.
not lead us to making a conceptual mistake of treating them
Hmm.
as subordinate or as the same
Hmm.
when it is compared with the constitutional basis for either reservations in government jobs or universities. So my
Hmm.
argument is that political representation, even both for practical and symbolic reasons, is prior to the act of
Hmm.
representation in the socio-economic domains of education or employment. And fundamentally, our constitution is an exercise in social democracy, right? It's
Yeah.
not a constitution that is importing Western style liberal democracy overnight. As my former classmate Madhav Khosla has argued, the point of
Yeah.
having the Indian constitution is not just to codify, not just to
Hmm.
centralize, but also to educate the
Yeah.
population or the citizenry in basic methods of political participation. So I think
Hmm.
while not fully agreeing with the way in which that argument is fleshed out by Madhav, my limited point is that the Indian constitution is adopting this policy with a very clear goal of
Yeah.
ensuring that the basic process of legislation and even popular representation is seen as
Hmm.
prior. And that
Yeah.
priority comes not just from later judicial interpretations. The priority is very
Hmm.
clear in the design of the constitution. So that's
Hmm.
maybe the main claim, which I think I need to perhaps substantiate better, is one of the comments that I got from the external examiners. But the other
Yeah.
point, which I think I should make in a related way, is that even if you think about how intergenerational benefits accrue, right?
Hmm.
Political representation is a more immediate solution, right? It talks
Hmm.
about giving an opportunity in terms of political voice or mobilization or even effective articulation of interests as soon as you secure an electoral victory.
Yeah.
Whereas in terms of benefits accruing to individuals and then translating into community benefits, that
Hmm.
process is much more gradual and much slower
Much more.
when it comes to the impact of educational or employment reservations. So I've had
Hmm.
this, in fact, I've raised this issue with some interlocutors and fellow scholars in the recent past, and not everybody is
Hmm.
comfortable uh, with the way
Yes.
in which I'm trying to set up a priority for political representation.
Understood. Also, I mean, when we talk about the design of the Constitution, and specifically the idea that political representation or electoral reservations are not part of the fundamental right, what is the logic behind it? Is there a
Yeah.
logic behind not giving it as, not calling it a fundamental right?
Yeah. So there is a textual answer. The textual answer is that
Hmm.
since the Constitution largely incorporates provisions from the Government of India Act of 1935, the
Hmm.
Government of India Act of 1935 itself had placed a discussion on electoral reservations bereft of a
Hmm.
reference to fundamental rights. But we must
Hmm.
remember that the Government of India Act of 1935 is a direct outcome of the Roundtable
Yeah.
Conferences. which had
Correct.
happened in the early 1930s. And as many scholars from the fields of history and political theory have shown us, the Poona
Hmm.
Pact itself is in fact a clawback or a partial
Hmm.
compromise, which is arrived at after the Ramsay MacDonald Award, which
Yeah.
had promised a double vote system to the depressed classes. So I think
Yeah.
if you read the Government of India Act 1935 in its historical context, then it
Hmm.
becomes very clear why the design of the legislatures was seen as an argument comparable to administrative machinery, and
Hmm.
how in the framing of the constitution also the same approach has been taken. So there's a
Hmm.
very interesting book which I think which I have referenced multiple times in my dissertation, but perhaps has not got the attention that it
Hmm.
deserves. But it is by a civil servant called Rajshekhar Gunduru, who had actually written
Hmm.
his thesis here at NLS, which dealt with the differences between not just Gandhi and Ambedkar at the time of the Poona
Hmm.
Pact, but more importantly between Ambedkar and Sardar Patel when the discussion
Hmm.
on the electoral system was happening in the Constituent Assembly. And if
Yeah.
you look at Rajshekhar Gunduru's book, he gives you a very clear, granular answer as to why
Hmm.
these provisions have ended up in a portion which is not the same as fundamental rights. The
Yeah.
simpler answer to your question is, even if you look at court judgments after 1950, the
Yeah.
tendency has been to not treat the right to vote or the right to contest elections as part of fundamental rights, even
Hmm.
bereft of the textual reference. So there are early
Hmm.
cases where the courts have been concerned about giving the right to vote the status of a fundamental right because petitioners have
Yeah.
come to court when
Yeah.
candidates have not been allowed to contest elections or they've been deregistered or the
Hmm.
affidavits have not been accepted by the election commission. There are cases all the way back from the 50s where
Yeah.
parties have come to court and said the right to contest elections is fundamental, the right to vote is fundamental. But we have a
Hmm.
long jurisprudence where, for regulatory reasons, those
Hmm.
arguments have not succeeded. But
Hmm.
obviously, that is not part of the original text of the Constitution. That is
Correct.
more of an interpretive stance which courts have taken later.
Hmm. Understood. Understood. Um, let's speak more about the case that you started off this podcast with, which was the Krishna Murthy. Now, on one hand, it expressly holds that the barriers to political participation are not really the same as the barriers for education and employment. But then, on the other hand, it also imports the 50% aggregate ceiling and requires effectively a Mandal style commission to show backwardness before any reservation can be granted. How do you read this judgment? What explains this pattern of consistently having this 50% ceiling imposed on electoral reservation?
Yeah, in fact, I mean, for those who may have the patience to read my dissertation, I've actually disagreed with this
Yeah,
observation because I've said that if you're willing to distinguish the domain of political representation from other
yeah,
domains, then you should not have imported the 50%
yeah.
ceiling, which was actually created initially in the context of technical education in
Hmm.
the M.R. Balaji case from 1961 and later reinforced in the famous Indira Sani case that dealt
Yeah,
with reservations in central government jobs. So
yeah.
the sort of granular answer to this is that since it was a five-judge bench decision, even though the
Hmm.
decision comes in the name of one judge, it reflects
Hmm.
compromises and adjustments made within the bench.
Hmm.
So, if I remember correctly, the arguments made by Sri Rama Joyce, who had
Hmm.
actually appeared on behalf of Dr. Krishna Murthy and opposed the expansion of OBC reservations in local
Yeah.
government, this argument also came from him. He was
Hmm.
making the argument that you cannot equate this domain with the other two domains because fundamentally they're different. But
Yeah.
his reasons for making this distinction were very different. He was taking
Okay.
the specific example of Karnataka, where
Hmm.
you had had successive backward class commission reports expanding the list of backward classes. And he
Hmm.
was actually showing evidence which suggested that while backward class reservations were implemented in the Panchayati Raj, these communities were
Hmm.
already well represented in the assemblies. So, if the
Hmm.
community is already well represented in the assembly, what is really the criteria for backwardness
Yeah.
to assess or who should be represented in the local bodies? So, it was in that context that Dr. Rama Joyce was making the distinction between the domains. He, of course, was a former
Hmm.
judge of the Karnataka High Court and was given due deference by the bench. But the
Yeah.
response of the central government, which I think was offered by the Attorney General at the time, was that look, the design of the policy may or may not make the distinction between the domains, but there are limiting
Yeah.
principles which the courts have recognized in the context of education or employment, and it makes sense
Yeah.
to apply those limiting principles. Now, I think
Hmm.
the bench itself is inconsistent on this ground because if they are willing
Hmm.
to work with the distinction of a distinction between domains, which is to say they're willing to take a domain-specific view and they're willing to give suggestions to look at this policy afresh, then they should not have accepted the argument about transplanting the 50% CV. But I think between the arguments made by the parties and between the different positions in the bench, this was possibly a compromise that was worked out when the decision was published. But as I show, and as I think as many observers of the court have realized, this contradiction in the Krishnamurti case has led to a lot of litigation afterwards. And I've only briefly surveyed that litigation in my own thesis, but I think there's already some interesting work on what's happening in Maharashtra and Madhya Pradesh as a result of this conceptual confusion.
Absolutely. I mean, the judgment effectively left an opening for future litigation to happen, even if they don't, even if they didn't really agree with the entirety of what one side was arguing. But like you mentioned, one of the arguments was about what constitutes as a measure of political underrepresentation. The example that you gave, saying that okay, in these legislative assemblies they were already represented, so therefore there's no requirement for electoral reservation. How do you then what would it take to become a real measure for political underrepresentation?
Right.
For education and employment, I think it's settled on. It's not fairly agreeable to a lot of people, but we know what the measure can be. What is it for political representation that the measure could look?
Yeah, great question. Because I think it is because of the Krishnamurti judgment that state governments were forced to reopen this question. Because the judgment makes a formal distinction between political backwardness and then social or economic backwardness, which is the phrase used in 16.4 and also cross-referenced in 15.4. So you're right, various states had their own backward class commissions, which had created empirical data, which was then used as the basis for creating the OBC lists for education and employment. The impact of the Krishnamurti case is that it is again asking state governments to conduct a separate exercise, right? Now, which data judgments are kind of reading as a triple test, but I think the test is only singular, that you conduct a fresh survey on questions of political representation. Now, obviously, not all the criteria that have been used, let's say the Mandal Commission report or the state level commissions which have used different criteria to assess social or economic backwardness, like access of housing, access to irrigation or safe water, or questions of access to education or income levels. Not all of those criteria are neatly transferable to this domain. But I think there is some wisdom in looking at some of these criteria, especially when it comes to access to education or access to health in your locality. But obviously, the emphasis also has to be on formal representation. How many candidates from those communities have accessed the state legislatures in the past or accessed the local bodies in the past when you make this determination? So because of the follow-up litigation, I think the Vikas Kishan Gawali case from Maharashtra and the Saurav Pandey case from Uttar Pradesh, courts have now had to clarify to state governments that you cannot rely upon your previous OBC lists. So in some cases, for example, in Uttar Pradesh, they have set up a dedicated backward classes commission to study political underrepresentation at the local government level. And then in Madhya Pradesh and Maharashtra, it has happened belatedly. So to that extent, I think the Krishnamurti case has managed to push governments to be more precise and to think of how underrepresentation works in these different domains. But the initial confusion about whether or not you could transplant the criteria from educational or employment lists and straight away use those lists also has led to a lot of loss of time. So in some cases, the immediate impact of this confusion has been delays in the conduct of local body elections. And I think that to some extent has undermined the role of local institutions.
Understood. Now I understand that, okay, you would want different criteria or different lists to begin with when it comes to political underrepresentation. But let's say that we grant them representation based on we look at how underrepresented they are in a particular constituency, and we grant them reservation based on that. The next question or the next roadblock that we hit is the 50% ceiling. Now, the argument is that, of course, you're borrowing this from a different domain. It does not apply on political representation. But my question is that what is the stopping point for reservation for electoral reservations? If proportionality is the standard, then and let's take the example of Telangana, where the backward
Right.
classes
Yeah.
are around 56% of the total population, and then you have the SC/ST shares on top of it. Uh, at this, if we take the 50% ceiling and put it aside, then the unreserved category becomes a structural minority in every local body elections. Is this a problem? That's the first question. And if it is a problem, then is there a principal limit that we should look at apart from the 50% cap that is imposed by Indira Sawhney?
Yeah. So this is where I take off my hat as an observer of the court and offer my independent
Yeah.
view. And my argument is actually very simple, that if we have to breach the 50% limit, which I know is the issue which some political parties are mobilizing on, like at the moment, the current leader of opposition, Rahul Gandhi, is making that argument at a populist level, which is probably what his consultants told him. But I would say that if any state
Correct.
government, or in the future, if a central government has to reconsider policies in this area, then breaching the 50% limit in the domain of electoral representation is the most rational thing to do. Which means if you have to experiment and you have to say that the rationale for this limit, which applies originally to technical education, has been later extended to central employment, does not apply at the level of state representation or local representation. By the way, we have enough exceptions, right? In many states which have been given special status, or where you have a higher representation of, let's say, backward classes, you already have some state laws, Panchayati Raj laws, where reservations in excess of 50% have been allowed.
Correct.
The Jharkhand Panchayati Raj Act is one example,
Yeah.
where in the 5th schedule areas, you have a reservation up to 80% for scheduled
Yeah.
tribes when it comes to Panchayati Raj. But there you might say it's the 5th schedule, and hence
Yeah,
that's the
you could
rationale
say.
for differentiation. So my provocative argument, which of course may lead to some disagreements in the future as well, is that if any government has to test the boundaries, then this is the domain where they should test them. And let's remember, Arnav, that when we are talking about proportionate representation in terms of the proportion of the community, are we fully accounting for the barriers that people face when it comes to
Yeah.
choice of candidates, when it comes to mobilizing through a political party, and eventually having enough capital to see representatives in the legislature? So even this assertion that, I know it's not your personal view, but even this assertion that general caste voters will invariably become a structural minority has to be balanced with the historical fact that these groups have been overrepresented.
Yeah.
So just as these groups have been overrepresented, I guess you and me belong to these dominant castes.
Yeah.
If we have been overrepresented in higher education or in bureaucratic jobs, and the 50% limiting principle then asks us to create a certain quantitative limit on how many
Yes.
seats can then be earmarked for scheduled castes, scheduled tribes, and other backward classes. For the benefit of readers, obviously other categories don't count, because reservations for women and disability are taken as cross-cutting
Horizontal.
categories. Yeah. So if we were to breach the 50% limit, as is the argument made in Bihar, I think it's an idea whose time has come.
Yeah.
We may not have the political alignment or the political will to do it at the moment, but it's quite foreseeable that under a different government in the future, it may well happen at the state level. In fact, even if you remember the public discussion when the Women's Reservation Amendment was passed in 2023, I'm not talking about this year's attempt, but when in 2023, when the government introduced the gender-based reservations in the constitution at the level of parliament and state assembly, what was the main demand of the principal opposition party? That please think about other backward class reservations as well.
Correct.
Because at the level of the parliament and the state legislature, you only had scheduled caste and scheduled tribe reservations. So
Right.
their argument was that we have already experimented with SC/ST, OBC reservations and cross-cutting gender reservations at the Panchayati Raj level, at the level of urban local bodies. So why can't that be the model for representation at the level of parliament or the state legislatures? So I think that's an issue which is worth considering, because then you may end up breaching the limits, but that may in fact be a better model for the future. The other
Absolutely.
technical point I wanted to convey is that we are still talking about an electoral system which is based on first past the post.
Correct.
So even though we may be using the word proportionate representation, it's not the same as proportional representation as an
Absolutely.
electoral method, where the legislative seats are assigned to the percentage of votes which are cast for a particular political party.
Correct.
So my argument is that even without thinking about proportional representation, or what we technically call alternative vote, when it comes to designing affirmative action policies, maybe the states are the right place to experiment with it. So if we have already made an exception for 5th schedule areas when it comes to reservations for scheduled tribes, There are some union territories of the country, some northeastern states, where we have already breached the 50% limit to account for the local demographics.
Yeah,
Why can't we recognize the demography in other parts of the country? Right? If there is
absolutely.
political will in the state of Bihar or the state of Telangana, for that matter, irrespective of which party is in power,
Hmm.
then that is the litmus test. We must experiment with that policy. Right? So that's the reconsideration I'm calling for. I know
Yeah,
it may not happen realistically in,
yeah,
in judicial arguments, but
yeah.
that's the position I'm taking.
Understood. And I mean, if we have to experiment it, it's what we spoke about earlier as well, that electoral representation is a prior to education and employment. So if you start with breaching the limit at this level, or even start experimenting at this level, the the impact that you will see will firstly be more immediate, and secondly will have a greater impact in terms of affirmative action policy.
Yeah.
um,
So, for example, the test case which is taken is Tamil Nadu, right, where
yeah,
the state level laws dealing with education or employment were placed in the ninth schedule. Now,
yeah,
it's a unique political circumstance because the ruling parties in Tamil Nadu were able to persuade the central government to do it.
yeah.
But basically, we are talking about a similar issue in the domain of electoral representation. Right?
Correct. Understood. Now, what I want to move on to is, the three limits that usually apply to reservations generally. Um, so, your argument is that none of these three limits should apply. I'll go through the three limits, and
Yeah.
you can give what your opinions are. The first is subclassification, which the court recently allowed in case of scheduled caste in the Vinder Singh.
Hmm.
You say that should not apply for political representation. The second is the creamy layer exclusion,
Right.
which you actually argue that the community would be better off if the members, if who would be considered as creamy layer, represent the group.
Hmm.
You can correct me if I'm wrong. And the third is the religious conversion exclusion. You say
Right.
that you should not disqualify a candidate from a reserved seat just because they've changed their religion. So these are the three different limits, and for
Right.
each
Yeah.
of them, your answer is that no, they should not apply. Why?
Yeah, so I mean, it may sound like a classroom provocation, but
Yeah,
as you have gathered, I've spent a lot of time constructing this dissertation, so I had
yeah,
time to think through each of these positions.
yes,
On subclassification, obviously, we now have the Davinder Singh judgment, which dealt with the fact situation in Punjab
yeah,
involving Mazhabi Sikhs, but we also had the earlier case of E.V. Chennaiya, where
hmm,
attempts were made to subclassify the SC reservation at the level of the state level jobs and universities.
yeah,
So subclassification, I think, would defeat the purpose of the electoral reservation, because
hmm,
sometimes even if there is internal differentiation in terms of access to jobs or access to university seats, which could be a
hmm,
function of the reservations working differently for different communities which are covered by the scheduled castes order or the scheduled tribes order, I
yeah,
think for electoral consolidation, numbers matter. So if
hmm,
we accept a principle of subclassification, even let's say at the level of a state, technically that can't happen because
yeah,
the identification of scheduled castes and scheduled tribes is with the center even
yeah,
now. So subclassification, I think, is going to undermine the goal of electoral consolidation. And
hmm,
while I have not tested this argument empirically, but even literature which is talking about, let's say, more effective representation by parties which are
hmm,
organically connected to communities, for example, the VCK in Tamil Nadu or the Republican Party of India in Maharashtra, and of course, the main example being the BSP. These
yeah,
parties were able to gain a presence in the legislative assembly and win a few seats in parliament
hmm,
because they were able to consolidate across the various communities. So I
hmm,
think the logic of subclassification will actually make it harder for parties who are representing the Dalit vote or the Adivasi vote or certain sectional interests. It will
but
actually
then
undermine
I
the goal
have,
of formal representation.
yeah,
It's not a
I
question
actually
of
have
competing for power
hmm,
because, yeah, and let me just finish the thread. The reason
yeah,
is that when it comes to university seats or employment seats, you're talking about the benefit first and foremost coming to the individual
hmm,
in terms of accessing that resource, and then that
yeah,
resource may turn into a community benefit or an intergenerational benefit.
hmm,
Whereas with electoral representation, it is about consolidating support and
yeah,
mobilizing opinion.
hmm.
Right. So, but you were seeking some clarification.
Yeah, so my clarification was that how do you balance this with political representation? So I understand that, okay, electoral consolidation is something that you have to look at, but the subclassification argument essentially would be that if within a community there are
Hmm.
sub communities whose interests are not voiced or would not be considered well enough if
Right.
you
Yeah.
aggregate that community.
Yeah.
That would be
Yeah.
the strongest argument for granting political representation. And I could argue that
Hmm.
if you want, if representation is the end goal, then having subclassification even for electoral representation helps achieve that goal. How do you counter that
Yeah,
argument?
no, it's linked. It's linked to the second question of
Yeah,
creamy layer, because
yeah,
the concern is that if there is inherent discrimination across different caste groups which are
mm,
part of the scheduled castes order, will it actually ensure equitable distribution of opportunities
mm,
to get elected? Right. Of
yeah,
course, the right to vote, we have to assume there is fair registration. People have
yeah,
a chance to register whether, even if they migrate. So that is, of course, an assumption being made. Though, of course,
yeah,
today we can't accept those
yeah,
assumptions.
yeah,
But by and large, the argument is, and here I think I'm being logically consistent, but you're right, there may
mm,
be such concerns that whether it is subclassification or immediate exclusion,
mm,
electoral reservations actually will come with the complication that those who are more empowered within the disadvantaged group are more
yes,
likely to secure electoral power. So, which means that political capital may come not
mm,
because of wealth differences or educational differences, but
mm,
largely the ability to mobilize votes. So,
yeah,
if you take the example, let's say, of Kanshi Ram, right?
mm,
Kanshi Ram himself may have an English education or an undergraduate education, but
yeah,
he became an effective leader of the BSP because he was willing to work with labor unions in Punjab and then
mm,
laid the foundations of his party, right? So
mm,
my argument is that if you have to incubate the next generation of talent from historically disadvantaged groups who have
mm,
structurally been excluded from higher education or public services in the past, then applying similar filtering principles in the context of
mm,
electoral reservations is defeating the purpose. For
got it.
example, a person who's got a university education or even a scholarship abroad may
Mm,
actually be able to articulate the interests of the community more effectively or
mm,
mobilize. Now, I know it's an intuitive claim, it's not an
yeah,
empirically grounded claim,
yeah,
because even then you have to see who got elected. And the
yeah,
common concern is that it is people from the same families who end up
yes,
getting elected. So, in fact, Professor Upendra Bakshi has this earlier
mm,
essay on this theme. I've mentioned that in my literature review, that the only two good essays which I could find by
mm,
legal scholars on this theme were both from the late 1970s. One
mm,
was a lecture given by Professor Upendra Bakshi at Madras University, and the
mm,
other was an article by Professor Mark Galanter,
mm,
which then later appeared in his book on competing equalities. And
yeah,
I've actually followed more the Galanter line of inquiry because
mm,
Professor Bakshi's lecture actually makes a very interesting claim that when
mm,
he interviewed some members of the Republican Party of India who had gotten elected to the Maharashtra Assembly, they were saying they did not want political charity. They
mm,
were saying that, we are confident that in the future we'll be able to get elected to the assembly minus
mm,
the electoral reservations.
yeah,
And that led Professor Bakshi to conclude in the chapter that, look, maybe in the future we don't need to extend Article 334, which is the
yeah,
provision for extending electoral reservations for 10 years. But
yeah,
very interesting, because 33 years later, he gave a speech at NUJS where he
mm,
explicitly says that my view then was wrong.
mm,
I got overawed by a few remarks made by a few overconfident legislators. And the
yeah,
same legislators over time who have stuck with that party have not got elected again.
mm,
So, which means this early confidence that initial representation in the legislature will lead to a deeper presence has
yeah,
actually not been met with evidence. So, I
mm,
think the most serious work on the subject from an empirical perspective has been done not just by Professor Mark Galanter, it was slightly outdated work
yeah,
because he was looking at the performance of Dalit and Adivasi MPs in the first four terms of the Lok Sabha. But
mm,
the one scholar who has really investigated with depth, with evidence, is Narendra Kumar,
mm,
who I think is still at JNU. And his
yeah,
own work had looked at the performance of Dalit and Adivasi, Dalit MPs primarily in parliament. That was
yeah,
his PhD thesis at JNU. And he's
mm,
done multiple books now to look at the performance of who is actually sitting as a sarpanch and whether
mm,
having a Dalit sarpanch and later a woman sarpanch has an impact on governance outcomes. Now,
mm,
my dissertation doesn't take an empirical track, but if I have
yeah,
to draw from this evidence, the question is that sometimes it is the relatively empowered sections
yeah,
of the disadvantaged community who are able to bring some semblance of a politics of presence and
mm,
then are able to ensure advancement for their communities.
yeah,
But if you hold them to the strict standard that,
mm,
look, historically you were excluded, but we
yeah,
want to ensure equitable distribution of representation amongst your community,
mm,
might actually be a hypocritical standard.
correct,
Because are we applying that standard to dominant caste groups who
mm,
have been able
yeah,
to dominate by virtue of their social status and then the capital that derives from it? So that's the reasoning which I'm offering in this case. On the
Understood.
third point, I think
Yeah.
apart from subclassification and creamy layer, there is, of course, the question of religious conversion. And I think since you've read my dissertation, you know that in
Yeah.
the early part of the third chapter, I tackled that area.
Yeah.
And there, the examples are very illustrative, right?
Mm.
You have an example, I think, D.P. Meshram and Punjab Rao, which are cases where people who were actually converting to Buddhism under Dr. Ambedkar's influence
Yeah.
have later not been allowed to contest on SC seats,
SCCs,
right?
yes.
So what does that example tell us? That you have suffered caste-based discrimination, you have faced untouchability intergenerationally, but because you chose to empower yourself by rejecting mainstream Hinduism, and one of these cases pertains to a person who was part of the Mahaparinirvana. So people who have chosen to opt out of the caste system are
Yeah.
now being told that you cannot claim representation under the affirmative action policy because you have stepped outside the Hindu fold.
Outside of the Hindu fold.
Now,
Correct.
that argument has been tempered to some extent because in the 80s, when VP Singh was in power, they added Buddhists to the scheduled castes order. But my argument is that why can't we extend the same for people who have embraced Christianity or Islam in order to escape the Hindu caste order?
Correct.
In fact, this question is has been investigated by the judge who I worked for, Justice Balakrishnan. He was chairing a committee specifically on the question of what to do with people who have converted and are still seeking access to affirmative action opportunities, especially for scheduled castes and scheduled tribes. But particularly the question was for scheduled castes. And I think they have prepared a report. It's not in the public domain yet. But my sense is that the report might be more pragmatic. The report may not be as forthright as I'm trying to be. So,
Absolutely. Thank you so much for that answer. I think all three limits you've explained well of how they should not apply to electoral representation and what the logic is.
and Arnav, also the reason is it's an academic thesis. So I'm not appearing in court. So I'm not worrying about what happens to my client. So I'm deliberately taking a provocative line because I want others to respond. I know there is a sharp disagreement. So I want others to respond to these propositions.
Absolutely. I mean, that's how you're having academic engagement, I hope. Now,
I mean, somebody should write a critical review or somebody should say, how can this person make an argument like this? That's fine. That's part of our profession. So
yes, absolutely. So now I want to close with sort of a theoretical, broad, overarching question. In your thesis, you draw on Luhmann and Teubner, who argue essentially that law is a closed system and it can only see the world through its own lens and its own categories. Effectively, every attempt that you make of justice inside of law will end up creating new exclusions and new injustices are born from it. That's fairly a pessimistic view of what the courts and what the law can do. But what you also do in your dissertation at the end is, effectively ask the Supreme Court to build a better theory for political equality and representation. If law is so structurally limited in the way that Teubner describes, why is adjudication and why is court the answer to all the problems that we've discussed today?
Yeah, great question. And since you're still a student at Nalsar, I think you have some sense of the answer that is coming. My supervisor is Professor Kannan, who teaches sociology. I think you've also studied under him. And this is frankly material which I had only briefly looked at earlier when I was a student. And it was largely his supervision which pushed me to look at this material more closely. In fact, to give you a very honest answer, I know maybe in a podcast this may not be the most appropriate answer. Maybe Professor Kannan's criticism with me primarily was that I was not accounting for these critiques when I wrote my initial draft. So it took me some time to understand where he was coming from. Which also partially explains why the dissertation took very long. Though, of course, there are other reasons, which I can't mention on this podcast. But the immediate reason was that Teubner's idea of self-subversive justice is not an argument that is grounded in one area of law. Though, of course, he's a very well-known German social legal scholar who's drawing on his own predecessor, Nicholas Luhmann, who had published a book called Law and Social Systems. So the argument there is that when we think about legal theory in the continental world, the argument of having a very structured hierarchy of sources, which is what English legal theory introduces you to, is not really the best way to think about law. So rather than taking the standpoint of HLA Hart, who draws the distinction between primary rules that govern us, secondary rules that underpin them, and then
Yeah.
possibly an ultimate rule of recognition, which also Hart acknowledges could be pre-legal or moral. The German scholars like Nicholas Luhmann have said that the better way to understand the law is to characterize it as one system, which is part of a network of interlocking systems. So the legal system itself is not fully autonomous, but it interacts with other systems such as religion or marketplace or communication. And in fact, Luhmann himself had started with the interactions with communication, which is, I think, material that you must have studied when you did your early courses here in Shamil Diamond. I hear now is Nagar Bhavi for me. So
Social
the
2
point is,
was largely this.
yeah, I mean, the relocation can do these things. Sometimes you're confused about what is here. So what happens with me is that when I start looking at the case law on electoral reservation, I had compartmentalized it by thinking about it as an area which comes within reservation law, which we textually study as an adjunct to the reservation law in general under the Indian Constitution. And I was approaching my research problem as a problem in the field of constitutional law. Whereas my supervisor's point, which I think I have understood partially, is that that is actually a wrong way of characterizing the field of inquiry. Because law at large is not a closed system per se, but the law is a semi-autonomous system which is interacting with multiple other systems at the same time. So in Luhmann's own work, which is published over several decades between the 60s and 90s, he looks at the interaction between different systems. Law in social systems is actually one of his later works. But Gunther Teubner, who was his student, talks about the autopoietic theory in law. And he looks at legal theory in terms of not just its potential, but also its inherent limitations. So the three ideas that I draw on from Gunther Teubner are actually not exactly the idea of a closed system alone. So he's saying the law is not fully closed, but it does suffer from what we call an operational closure, right? So the law is drawing on influences, organized religion, organized government, organized markets, family systems, communication systems. But the way in which we understand legal interpretation has to both acknowledge the fact that the law is interacting with these other social systems, but even in that course of interaction, the law retains its own distinctive character. So this process he describes as an example of operational closure. That when judges or lawyers or even legal scholars are trying to find answers to new questions, they invariably fall back on what they think are the boundaries of their discipline. So this is the idea of operational closure, which then has other implications. The most obvious being that there is a self-referential character of legal reasoning, which dominates not just in the English common law tradition, but to a large extent even in appellate adjudication in the European context. The third idea, of course, is more obvious, which is binary coding, that legal theory itself assumes that we can work out an answer that benefits a party or is at the cost to another party, or we award a punishment, or we decide to acquit somebody. So the law also works with this binary coding, which is built into not just judicial interpretation, but also how we study and interpret the law. So I think my supervisor's main point is that, like other areas of adjudication, perhaps there is value in demonstrating how these limits are quite inherent to how the courts are dealing with an area which, in terms of subject matter, is clearly distinct from how older precedents in reservation law have been shaped. But even when there is an opportunity to make a fresh extension, to bring some fresh thinking into this area, the courts fall back into the habit of importing doctrine from other domains. So that's the connection I've tried to draw between the idea of the operational closure and what I think are conceptual mistakes made in some of the decisions that I have covered in chapter 3. But to be fair, I think this portion requires more substantiation. So at the moment, of course, I've approached a publisher and I hope to convert this into a full-fledged book in the next few months. And certainly to make the argument more accessible to readers, I may have to substantiate this portion a bit more. You've taken a course in sociology of law, so you were able to get the question.
I was able to follow.
I think but we have to make the discussion more accessible. The last thing I'll say is that it's not really pessimism. So even if you take Teubner's main article on self-subversive justice, there's a great article from 2009 where he follows up on his earlier discussion and Luhmann's discussions. Remember, the idea of self-subversive justice is not a critique of the judicial system. It is not to say that judges will always get things wrong or lawyers are hopeless because they will make arguments for their clients and in the long run what will happen. I don't think it's a pessimistic approach. It's
Okay.
basically a tool to understand the long-term change that happens in legal interpretation. So
Hmm.
even if you're trying to deal with new facts, a new technology, a new social situation, or in this case, a new social policy, your ways of
Yeah.
thinking are shaped by how your system itself identifies itself as unique, right?
Hmm.
So that is the idea of autopoiesis. Even though you
Hmm.
have inserted me into a new system, rather than
Hmm.
swimming and learning and working with the tide, I'm still held back by some established methods or my
Yeah.
conditioning. So it's not a critique of a particular judge or a particular court or even a critique
Hmm.
of a particular decision. I think
Yeah.
it's an attempt to say this is the inherent limitation in legal reasoning
Of
across
this.
jurisdictions.
Yeah.
Now, there is, of course, debate on whether their criticism applies more to common law or to civil law. And the
Hmm.
obvious implication is it applies more to civil law. But I
Hmm.
think there is value if Indian legal scholars also start engaging with this material. Because to the best of my knowledge, a lot of writing in India, especially on the field of legal theory, is
Yeah.
largely following the English American common law frame. And we
Correct.
don't engage too much with systems theory or
Hmm.
social theory. In
Yeah.
fact, there's a recent Edward Elgar volume on law and social systems and law and systems theory,
Hmm.
which are good resources for us to catch up and to understand
Yeah.
this literature. One challenge is most of this literature originally came in German and then later got translated to English.
Hmm.
So it's still not a core part of the
Correct.
curriculum that most law schools in India teach, but this is certainly material which my
Hmm.
supervisor has pushed me towards. So it was a learning experience for me as well.
Yeah. No, this was very helpful. Even when I had this question, I went back and I looked at some of the Socio 2 readings to figure out what it was. I'll be honest, I didn't understand too much of what the argument
Right.
was, but I think this helped clarify, and conceptually it made me understand of what the central argument is. And especially I love your answer about how it's not pessimism, it's just inherent limitations within any system, and it's just recognizing those inherent limitations. All right, Dr. Chauhan, thank you so much for taking out the time to speak with us on this really relevant topic, and I'm so glad I could pick your brains on all these details and nuances. Thank you so much for joining us for this podcast.
No, thanks, and thanks for making the effort to read the dissertation. And I must mention, since I think the podcast will be publicly available, since I
Yeah,
was at Nalsar for 11 years, I was
yeah,
advising the students for the Courts and Constitution Conference, which is the major
yes,
event which the Law and Other Things blog organizes. But the blog has also been doing well. So for listeners
yeah,
who've had the patience to listen to this conversation, please check out the blog. Please read the pieces written by the students, which are currently the group at Nalsar is curating it, but they carry
yes,
content from law students and scholars across, and it's become a great resource for studying Indian public law. So I'm very happy to see the project growing from a distance, but I guess with mixed feelings because after having been involved in the same for some time, now one can see it from a distance.
absolutely, sir. Thank you so much. Thank you.
Thanks. Thanks.